Hello, and thank you all for attending. My name is Christian Thadani. I work for the Small Business Administration. I'm here in partnership with SCORE. Today we have Stephanie Cumley, who is going to present HR issues with HR. And thank you for coming. Thank you for attending. I'd like to thank Katie for setting this up. This is great. Really appreciate it. Appreciate you for coming. Stephanie, thank you.
Thanks, Christian. Thank you for having me today. Today we're going to talk about employment law. So I know many small businesses, you've got a lot of things that you have to consider as part of running your business. And there's also things, once you start hiring employees, you're going to have to take into consideration all of the employment laws that you need to follow. So just wanted to let you know, I am not an attorney, so nothing we say today should be construed as legal advice or tax advice. So if you need that, you need to consult your attorney or a tax professional. Oops, I scooted too much there. So I've been in human resources for 25 to 30 years, and been working with the last 8 years, working with small businesses, working with clients who have a lot of HR needs, whether that be in handbook or job descriptions, working on their compensation plan, and just in general answering questions as they come up regarding best practices. We talk through situations, and so those are kind of the services that I'm able to provide. So again, we talk about all of the employment laws that we have to deal with. And if you'll notice that the federal government has to enforce 180 different employment laws. So that doesn't necessarily mean that all of those apply to all businesses. There are many that are strictly related to federal contractors or other organizations. Some are dependent on your company's size. So you can see here we have several different laws. I just picked out some of the more common ones that employers need to be aware of. And again, you can see over the history here, we've had several passed. In addition to federal laws, we also have to consider state and local laws. So one thing that these are kind of some of the more common state employment laws that we'll see out there. Every state is different. So if you operate in Missouri only, then you only have to worry about Missouri law. But if you have employees who are working or sites in other states, you will need to consider in the state laws in that state. There are some ordinances at the local level that you'll need to consider as well. All right, so all of those laws that you just saw up there, they basically create what we call protected classes. And there are several different protected classes that most employers need to be aware of. Title VII of the Civil Rights Act does protect discrimination based on race, color, religion, sex, and that does include sexual orientation and gender identity. Originally, the EEOC had considered that as part of sex discrimination, but it wasn't until a few years ago that the Supreme Court actually confirmed that sex discrimination does include sexual orientation and gender identity. And then we also have national origin. We have age discrimination laws. That is ADEA and the Older Workers Benefit Protection Act. Disability, we have the Americans with Disabilities Act. Now that does only apply to employers with 15 or more employees. However, I hear some of my clients will say, well, I have fewer than 15 employees, so I don't have to worry about disability or accommodations or anything like that. Well, that's not actually true, because the Missouri Commission on Human Rights actually protects employees that have 6 or more, or employers that have 6 or more employees. So we do have to take that into consideration. And then we get into gender and sex. We have the Equal Pay Act. Again, cannot discriminate between employees based on gender. So if you have male and female employees within an organization, you do have to take that into consideration and making sure that you're providing equal pay for equal work. Genetic information, we have Pregnancy Discrimination Act, Citizenship and Immigration laws, and then of course USERRA is the military, the Veteran and Military Service Protections. So. All right, so why is this important? Well, as an employer, It's important to know that the EEOC does take complaints from employees who might be disgruntled or feel like they've been discriminated against, harassed, any of these kind of protected, under these protected classes. In 2021, there were 34,332 retaliation claims filed with the EEOC. That's just the EEOC. You also have the Missouri Commission on Human Rights, and employees can file at the state level as well. So a lot of money went out, and because the EEOC did side with the employee, and employers were forced to pay money as part of damages for that against that protected class. So we're going to talk about compliance, and what I've done is kind of picked out some of the things that I get questions on a lot from small businesses. They're starting their business, they're not sure how to do certain things. They're not even sure if some of these even apply to them based on the size of their company. So the first thing everyone needs to know is that every employee that comes into the organization is required to fill out an I-9 form. And it doesn't matter your company size, if you hire one employee, you do have to have that employee fill that out. So that must be done on or before the first day of employment. So a lot of times I'm going and doing audits for employers, and I'll see that they know that it was a week later before they got that employee to fill out that I-9 form. And there are penalties, and we'll go over that in just a minute. So it's important that the employee fill out section 1 and fill it out completely. Sometimes when I'm doing audits, I'll notice, fields are missing, which can be, they can issue fines for that. So make sure that these are completed thoroughly. Make sure that they are indicating their citizenship status. All right, the next thing is I have 2 daughters that have been in the workforce, and they'll come home and tell me, my new employer told me I needed to bring my driver's license and my social security card in for my first day. And that's actually not allowed. Employers aren't allowed to do that. Basically, you want to say you can bring something from list A of the acceptable documents or from list B and list C. So not everybody has a driver's license. Not everybody has a social security card. There are other acceptable documents that can be provided to the employer. So just be careful not to tell a new employee what documents they need to bring. They just need to know that these are acceptable ones. All right. The next thing is, if you do accept a social security card, you want to make sure that it does not say not valid for employment or valid for work only with INS authorization or DHS authorization. Those are not valid forms of acceptable documents. All right, so we get into section 2. This is the employers section. This is required to be completed on or before the 3rd day after date of hire. So if you hire somebody on a Monday, and when we say hire, that means they're working for pay. And so we need to make sure that they that date is correct. So you'll need to fill this. They need to provide you that documentation by the end of that time period, and you need to complete this form by the end of that time period as well. So I do often see that employers, they'll fill out the driver's license in list A and the social security card in list B. You can be fined if you're not filling them out in the right columns. They call them paperwork errors, and it's, to my understanding, if they come out and do an audit, the government comes out and does an audit, they are fining companies for these paperwork errors. With COVID, they did allow us to verify documentation virtually, and because of COVID, and a lot of people were working remotely, and it was a way for employers to still, bring them in through that hiring process. That has been extended until October 31st of this year. I don't know if they'll extend it past that, but until then, you can still collect this information virtually. Once they come in and begin working in the office, then you would update this additional information section. And that section is where you could put notes in there where you verified it virtually, and then maybe you put another date in there, you verified it in person when they return to the office. So, and that's kind of what that might look like. All right, and then I'll see a lot of employers will fill out this section because they just keep going down the form, they keep filling stuff out, but this is actually not something you want to fill out for every new employee that comes into the organization. It's really, its purpose is if somebody has a change of name, they got married, they have a new last name, you can fill out this section, which is helpful when you're doing an audit to know who that person is. And then also the date of rehire. So if you have somebody coming back and they've been employed with you, it's been less than 3 years since since their original hire date, you can just put in date of hire and they don't have to fill out another I-9 form. The section C is the one that it's a little confusing. It's asking for if their documentation is expired, if you need to go in and update that. That's actually only for certain documents that are provided. So for a driver's license, you do not have to go in and put the new driver's license information after it expires. For a passport, US passport, you don't have to do that. So really, if you get something from 3, 4, and 5 or 7 on list C, those are ones you might want to consider looking into as far as that's concerned. So those are probably the only ones you'll ever have to complete and get re-verified with the new expiration date. All right, it is important that you retain these for at least 1 year after date of termination or 3 years after hire, whichever date is later. And again, like I said, you can use the original I-9 if it's been less than 3 years since they originally were employed. So this is just kind of an example. If they're hired on 2/18, they term on 4/22, you would add 3 years to their hire date, add 1 year to their term date, and then you would determine which date is the later date, and that is how long you have to retain that I-9 document after they terminate employment. And then I've got some rehire examples there. So why is it important? Well, you'll notice that there are fines and penalties. For paperwork violations, as I mentioned, they can fine you up to or from $252 to $2,507 per violation. So every error that they see on these forms, that money starts racking up pretty darn quickly. If you knowingly hire somebody who is not authorized to work in the United States, we've got even heftier fines for that. So this process is important. I know I worked with a lot of small businesses. They just don't see the importance of getting this done timely or done at all. And I, you know, when you look at the fines and how much that could rack up, that can get pretty hefty pretty quick. So make sure you conduct an I-9 audit if you've got employees, identify errors, prepare remedy memos, and correct errors before you're audited. There are special ways you can correct those documents. You can't use whiteout. You need to cross through the incorrect information, initial and date with the date of that correction. Make sure that you're training anybody who is a part of that process. So the next thing we have is E-Verify. I get this question a lot. So employers are like, I hear about E-Verify. Do I have to participate in that? Well, at the federal level, if you are not a federal contractor that has a contract that contains a federal acquisition regulation, they call it the FAR clause, you do not have to participate in E-Verify. Basically what E-Verify is, it's kind of that second layer of the I-9 process. So you take the information off the I-9, you run it through the government E-Verify site, and then it's checking those records for you. It's checking to make sure it's the social security card number that was provided is not of somebody who's deceased. It's checking to make sure that the passport picture that you saw matches what's in the government system. So it's just kind of another layer of checks and balances on that process. For Missouri, only public employers and all businesses with state contracts and grants in excess of $5,000 are required to participate in E-Verify. So that excludes most of us companies out here. So one thing I did want to mention, I'd worked with some employers who were rapidly expanding to other states, or they had remote employees who were permanently resided in those states. And you'll notice here, we get down to kind of the green ones. All or most employers do have to participate in E-Verify. I began working with an employer who told me that they expanded into, I think it was Tennessee or one of those states. They didn't know they were supposed to do E-Verify, so they came on board. We tried to get that quick process started quickly. They had already expanded before I began working with them, and they ended up getting a $1,000 fine because they had 2 employees who came on board and they had not realized that they needed to participate. So they are monitoring that, and they're watching those new employers coming into those areas. You also want to check your local ordinances. Years ago, Springfield actually passed an ordinance that said that all employers need to participate in E-Verify. They did end up rescinding that. So at this time, there's no requirement for Springfield employers. As far as fines and penalties, well, it really comes down to, are you going to lose your federal contract because of it, because you're not participating? And then other states have other fines. So that one employer at that state, they had $500 fines per employee for not participating. So, all right, so verify your participation requirements, register if you are required to do that. And you never want to run all of your employees through E-Verify if you begin participating, unless you have a federal contract that says you have to. You only want to verify new hires going forward. Again, if you need to check to see if you're already registered, you can go on E-Verify, and they have a search function where you can check your own company name. So, all right, we're going to get into workplace posters. And so with workplace posters, employers are required to post these. Now, it is based on the size of your company. So all employers who have at least one employee do have to post the federal posters of the first 4 there. Those were kind of the last revision dates. And then if you, it's not like somebody's out here going business to business, checking to see if you have these posters up. I mean, it's just not happening. But if you are in if you have any government agent coming in to do an audit, or, you know, you get a lawsuit, they're coming in to check your records, it's possible they could go look for these posters, and if they're not up, you could end up with a fine related to that. So pretty hefty fines there. You can see for not posting those. For employers who have 15 or more, EEO is the law, is a poster you have to do. We kind of recommend that everybody post that because you do have some obligations, but if you go through a poster company, you're going to get that poster anyway as part of that all-in-one. Only employers who have 50 or more employees have to participate within 75-mile radius, have to participate in FMLA. So that's not necessarily a poster, but again, if you order an all-in-one, you're probably going to get that poster anyway, which is not a bad thing because it does state, you know, which employers have to participate. There are different posters for federal contractors, state and local government employers, agricultural employers. And if you employ somebody with a disability that you're paying lower than minimum wage, there's another poster for that. So we have to be careful there. All right, state and local. So state, for Missouri, there's 4 posters. All employers should be having posted. And then last fall, Missouri passed the Notice to Victims of Domestic and Sexual Violence Leave. That is for employers who have 20 plus, and then they have to provide 1 week of unpaid time off, and then you get into 50 plus, and that goes up to 2 weeks of unpaid time off. So many employers don't know that exists, and so we just want to make sure everyone is aware you do have to provide that time off unpaid, but it does need to be provided. There's some other ones. It really just depends on your business. If you're employing children under the age of 16, you do have to have a poster for that and list those individuals on that poster. We also have some other ones, discrimination in housing and public accommodation. Again, you just kind of have to understand what your business is and whether those are going to be applicable to you. And we have some other ones. So one thing that I do want to bring up here, I don't know, no, it won't. So you'll notice on in any handouts that we have, there's actually links to the federal and state sites where those posters are housed. So you can print those, all of those posters are on there. They're free for you to print and you can post. So you don't have to go through a poster company. A lot of people pay for those all in one because they look nice and pretty and they're all condensed into one item. But you certainly don't have to pay for those. So ensure you've got all your required postings. Make sure they're in a common area where all employees are going to be able to see those or pass through that area. If you have employees on a job site or they're working remotely, you need to provide those somehow. So on a job site, it needs to be in the work vehicle, or you know, if they're telecommuting, you need to have an electronic board or email it to those individuals. All right, so we get into governmental reporting. Another question I often get is, do I have to do EEO reporting? I hear about that EEO-1 report that everybody's, you know, filing. That actually only applies to employers that have 100 plus employees. So most small businesses will never have to worry about this. So I'm not going to go into a lot of detail on that, but just to be so you're aware that that does exist. We get into federal contractors again, assuming most small businesses aren't going to have federal contracts, but I do know of some who do. So I didn't want to not talk about that today. But if you have a federal contract that requires affirmative action obligations, then you're probably going to need an affirmative action plan. You need to get with an attorney to make that determination. That is really just tracking information from employees and applicants with regard to their basically their race, ethnicity, gender, disability status, and veteran status. So I do see a lot of times where small businesses that have 10 employees, they don't have to do EEO-1 reporting, they don't have to do affirmative action, but for some reason, as part of the application process, they're asking about their sex and race ethnicity because they think they have to collect that information. And that's not actually true. It's actually could be used against you from a if you're discriminating against somebody. So, so it's just, these are the situations in which you need to collect this type of information. Federal contractors also have to do VETS reporting, and if they have more than 50 employees and 50,000 in contracts, they're also going to have to do the EEO-1 reporting. So we get into OSHA laws. There's on the OSHA website, there's a list of organizations that are considered partially exempt. The reason it's partially exempt is because they're not 100% relieved of all OSHA duties. They don't have to do record keeping, like they don't have to do the 300 log, the 300A. They're not having to do that. But if they have an employee who was injured in an accident and they lost an arm, they may have to at least report that to OSHA or as part of their job duties. Or if you have an employee who was killed in the line of duty, you may have to report that to OSHA. So that's why they're called partially exempt. And they're on our handout, there is a link to that OSHA site where it lists what companies don't have to report. So like your financial institutions, they're partially exempt. And you're going to use your NAICS code. So you need to know what that is so that you can go on there and determine where you fall. So we get into covered employers. You've got your OSHA 300 log and your OSHA form 300A, which is the summary. So employers who are not partially exempt and their NAICS code is not in that list do need to do their log. So that needs to be posted, or excuse me, the summary needs to be posted from February 1st to April 30th. So that's something to take into consideration. And then we start getting into electronic reporting requirements. So this really comes down to whether you're high risk or not high risk, and we get into larger number of employees at that point. All right, so make sure you're setting up systems to collect the required information if you do have to collect it, and that you don't retain that as part of somebody's personnel file. It needs to be separate. And then of course, develop plans if necessary, and do monitor your requirements under OSHA. All right, so we're going to get into personnel and HR files. I know I get questions about this a lot. How do I structure my files so I'm not in trouble? Well, there's really no laws that say you have to do this and this. What it really comes down to is how do you have it structured such that you're minimizing your risk for supervisors to discriminate against somebody because they've seen that information in somebody's personnel file. So we do recommend that you have a personnel file and a separate payroll file. That's only if you've got different people doing those functions. So if you have a payroll department over here and a personnel department over here, you may want two different files because you don't want to have to file together. If that's the same person, you can probably keep that all together in one file. We get into the medical file, that needs to be a separate file. So you're going to have one file for every employee for their personnel and one file for their medical. And that's going to be your insurance enrollment forms, anything related to disabilities, anything related to leaves of absences where you've had to collect medical information. All right, you need to keep that for the duration of employment plus 7 years. 401k can be kept in the personnel file. I don't recommend that because number one, it depends on your 401k plan. So if there's a force out option where everybody that leaves the organization is required to move their money out of the plan, great, you can put it all together. Probably not going to have an issue there. If there's a force out option that says if you have more than $5,000, you can keep your money in the plan, but if you have less, you have to, roll it over into an IRA or do something different with it. Then you're going to want if they're not required to be a force out, you're going to want a separate file. And the reason for that is they're going to be in your plan for possibly longer than 7 years after their date of termination. And so you don't want to lose those records related to their 401k participation. And worse yet, you don't want to lose their beneficiary information related to their 401k plan. Many of us remember when the tornadoes went through Joplin, and there were a lot of employers who had paper documents for beneficiary information. So the tornadoes went through, a lot of those employers not only lost their entire business structure because it was destroyed in the tornado, a lot of those personnel files also got destroyed in that tornado. In addition to that, there were people who perished. So there were literally employers who had no idea who the beneficiaries were for some of their employees who had perished in that tornado. So it's important, if you're going to collect this yourself, you need an electronic backup of the beneficiary information. At the very least, that's what I tell employers. All right, same way with life insurance. If you have life insurance beneficiaries, keep that backed up electronically so that you've got record of who those individuals are, because they lost that information too. All right, there's other files. These are ones that we kind of recommend that you keep separate files. You don't have to have a separate one on every single employee, but you can keep like one folder for all of your employees. And that would be like your motor vehicle checks, your background screenings, your employment income verifications, garnishments, and any other credentials. And the reason I say that is, and again, it just depends on your size of organization, who has access to these personnel files, all of these documents, who's handling the credentials, who's handling the motor vehicle. You just need to do what makes sense for your organization. Just, those are ones that just to be thinking about whether you want to keep those separate or not. All right, and then I get the question, what do I do when somebody terminates? We've got all these different files. Well, the three that I mentioned, the personnel, payroll, and medical, you're going to combine that into one folder together. And then when the 401k when they're forced out of that plan or when they're no longer participating, you can move that over as well. So you're only maintaining one final folder for those employees. And then you can move documents from these other folders as well. I know it seems like a lot. And again, you just need to make sure that makes sense for your organization on how this is structured. All right, make sure that those are stored securely. So we don't want anybody being able to walk in and access those personnel files. That could put you at risk. All right, so we get into other types of HR files. These we recommend keeping separate because your I-9s only have to be kept for 1 year after termination. So keep those in a separate folder so that you can move those, purge those as people as you can. So we put purge dates on each one. Unemployment's only 3 years, work comp is 3 years. However, if those records relate to any type of exposure and medical evaluations, those have to be kept up to 30 years. And keep in mind, this is based on Missouri's record keeping and federal law. We kind of put all that together and then did what we thought made sense administratively to retain these documents. OSHA is 6 years, and again, back to exposure records are 30. Recruitment is 3 years. Investigations, again, retained for duration of employment plus 7 years. But you also want to retain those for 3 years after final disposition if there's any type of suit. So payroll is 7 years. Now, end of year pay registers, I recommend keeping for the duration of your longest term employee. And the reason I say that is because the Lilly Ledbetter Act, she worked for Goodyear, and she filed a suit against discrimination for equal pay act. And basically she lost that, not because of the fact that they didn't think she was being discriminated against. It was clear that she was not being paid the same as her male counterparts. What happened was they said the statute of limitations had run out. And so what happened was the she ended up going all the way and getting a law passed on this. So it resets every time there's an act of discrimination, it resets every time. And so literally it could go back to somebody's first day of employment. So it's a little crazy. All right, we get into payroll, or excuse me, taxes 7 years, insurance 6 years after the plan was last in effect, and then retirement, same thing, after the 6 years after the plan was last in effect. So I'm not going to spend a lot of time on our employee handbook, but I did want to mention these are some policies you'll want to consider, and that's just going to be based on the size of your organization, and it's going to be based on whether it's really applicable as something. I do caution, if you're doing an employee handbook, be very careful of putting too many specific details in there, because once you create a policy on something and it's very specific, it doesn't give you the latitude to carry that out. And if somebody claims, you know, that they were discriminated against or whatever that might be, it goes back to, did you follow your policy? And I found that most employers and their managers are not exceptional at following their policies to a T. So that kind of works against you. So be very careful that you don't include a lot of policies you don't need, and that you don't include too many specifics that will actually work against you rather than for you. So something to be cautious of. I did want to mention, some of these are just pretty basic. I do get a question about the safe harbor, and that is, there's several employers that I've seen over the years that dock their exempt employees when they're not there. And so you just want to be very careful. The safe harbor policy kind of details out when you're allowed to dock an employee, when you're not, and it does require the employee to come to you if they think that they're not been paid correctly. So that's one that may or may not be important to the organization. I've worked with one company, and their owners were the only ones who were exempt, and so it didn't make sense to put this policy in there. So getting into our time off and leaves of absence, of course, we get into some of these. Voting is a law, and in Missouri, you have to allow up to 3 hours of paid, or excuse me, of time off, and that does have to be paid if there's not enough, if there's not 3 hours of time in which the employee's not working and the polls are open. So if somebody's working 8 to 5 and the polls are open 7 to 7, then you may need to allow them off at 4 o'clock. If it's like a presidential election, you know, it might take a long time to get through the voting line. So, and then you would only have to pay them for 1 hour because they were only scheduled till 5, but you've at least given them 3 hours to do that. So those are things to consider there. We get into military leave, crime victim. Again, these just go back to your policies and the law. I mentioned the domestic violence and sexual assault. That's really only for companies that have 20 or more employees. Civil air patrol is something that most employers in Missouri do not know exists. Again, these are Missouri laws. I just want to say that if you have employees in other states, you need to look at those state laws. But civil air patrol is only for employers who have 50 plus. And of course, FMLA is the same way. All right, again, I'm not going to go through every single one of these, but these are ones you may consider adding if applicable and if it makes sense for your organization. Update it annually, so if you have changes, and make sure that the laws are up to date, and then make sure you train your managers so they understand how to carry those out. All right, so we get into recruiting. A couple of things I do notice on, especially with small businesses, they pull some employment application off the internet and they just begin using that. And there's a few things just to be cautious of. Old employment applications used to ask for date of birth, which goes against age discrimination, right? So we don't want that question on an employment app. Also, I see in the education section where they'll ask for graduation date. Well, again, that goes back to age discrimination, or it could. So we just want to ask, did you complete your degree, or did you complete all 4 years? Not the actual date that they graduated. Other things you might want to consider, most employees are not comfortable with their social security number. It does create a risk for you, because if you've got those laying around, you've got confidential information that is not, you're probably not protecting very well. So most employers aren't including that, and some employees don't have social security number. All right, we get into driver's license. Really, that's only important if it's required by the job. So if you don't need that information, don't put it in your job application. But if you do, it's acceptable. You just have to justify it. Criminal history. So Missouri is not what we call a ban the box state, but there are certain localities in Missouri that are. And so you just have to be careful and make sure that you're researching that and you know what those laws are. So I think Columbia is a ban the box locality. And so basically ban the box means that you cannot ask about an employee's criminal history, arrest records, anything like that on the employment application. The purpose of that is so we can kind of push people through the process without stopping them at the beginning and them being discriminated against because of that potential history. You know, it may have been 20 years and yet they're still being punished for that and they've served their time. So we want to be able to move people through. Salary history is becoming those bans are becoming a big thing. We're seeing states pass these laws. Kansas City has a salary history ban. And what that means is we can't ask about somebody's salary history on their employment application, and we can't even talk to them about their salary history in the recruiting process. So employers are really struggling with this because really what it's doing is forcing them to go out and verify the market value for these jobs, put their pay ranges in place so they know what's reasonable to offer somebody. And again, part of that is to force employers, because we're keeping certain classes of individuals down by they never get up here because they're just offered at or just slightly above what they were making in their previous job, and we don't see that advancement in their compensation. So that's something that I think we're going to see more movement at the state level in different states and localities as well. All right, so we get into, again, make sure you're not collecting certain information if it's not required as part of affirmative action plan. And then do have an applicant statement disclosure that's usually talking about, hey, we background check, we drug tests, you know, those types of things that they're signing off on as part of that application process. Understanding your employments at will, those types of things. And do provide multiple ways to apply because we don't want somebody who is disabled not have an opportunity to apply for a position because if you have, we can only apply this way, it restricts them from having those opportunities. I know there was an employer one time who you had to fill out your application at a kiosk, right? That was the only way you could apply for a job with that company. The kiosk was here, right? So somebody who was in a wheelchair could not reach or even see the screen. So just be thinking of those things through your application process to make sure you're not inadvertently excluding people who might be qualified for your job. All right, so we get into background checks. You know, consider the types of checks. There's a lot of different ones out here. Again, not all of these are going to be necessary. Criminal is usually the most common one. I see that's just the basic one that many employers will do if they do background checks. Some of these others are just really relevant only if it applies to the types of positions they're hiring for. Be cautious if you're going out on your own and you're looking at social media, you're pulling up Missouri CaseNet because number one, the CaseNet may not be the right person. You might be looking at somebody who has the same name, but it's not that person. So that's something to be cautious of as well. And then also social media, you might find something on there that they'll say that you discriminated against them because you saw that on their page. So we want to be cautious of that as well. All right. If you offer somebody, these should be done after you offer them employment. Again, trying to move people through the process and give them a chance. If you rescind that offer as a result of what you find in that background check, now you need to send an adverse letter, and that's part of our FCRA disclosures that need to go out, and then you'll need to send that letter explaining why you weren't able to, or why you had to rescind that offer. Let's see here. Drug testing. Oops, that's the Fair Credit Reporting Act disclosure. And then we get into drug testing. If you start doing this and you're not doing it before, there's what we call 5-panel, 7-panel, and 10-panel. And it really comes down to what types of drugs are you going to test for as part of that process. So that's something I encourage you to get with your attorney or that drug testing company to work through that. There's pre-employment, there's random, reasonable suspicion. So if we suspect they're under the influence, we're going to send them for testing. And then of course, post-accident testing, we can test for that. And then time frame. So many employers will ask me, well, how long do I give them to go and do their drug test? Well, I've seen employers say, we give them a week, we give them 2 weeks to go do that. Well, guess how long some of these stay in your system? Maybe not that long. So if you're really trying to capture anything that they're doing, just be aware that there might be some timeframes that you want to consider when you're kind of determining how long you give them to go do their drug testing. All right. I do caution if you're doing any types of assessments or skills testing, first of all, that's fine, but we start getting into personality testing. If we can't relate it back to the job itself very well, it's just not a good practice to do that. Could get into a little bit of weird discriminatory things. So we get into documents, offer letters. I do see a lot of offer letters come through, and they're just, some are concerning because first of all, they don't mention that it's an at-will employer. And so if you're not doing that, you could be insinuating that you're creating an employment contract with them. So make sure you say that. You also want to say that this position is this offer is contingent upon drug testing, background check, I-9 verification, all of those, or employment verification. All of those things are important because you may end up having to rescind that offer. A lot of people will put, I'm going to provide you an annual salary of $50,000. Well, again, you don't want to look it to appear that you're creating an employment contract. So you say, we'll pay you X amount of dollars per pay period, but when annualized or annualized over a 40-hour work week, then it's $50,000. So be careful of the wording on those offer letters. You might want to mention exemption status. You know, if they're eligible for, if they're non-exempt and eligible for overtime, you can mention that. If they're exempt and not eligible for overtime, that's something that could be included. And if you do include any details about benefits in that offer letter, make sure you have a disclaimer that those benefit plans are subject to change, and those rates that you might be quoting are subject to change. So be careful about adding that. We don't want to create any type of impression that for the life of their employment, they're only going to pay $60 a month for their health insurance benefits. So, let's see here. Employment contracts, again, there might be a business reason for doing those, maybe at the executive level, and that's perfectly fine. Get with an attorney to get those drafted. Non-competes are very hard to enforce, getting even harder. And so it's important that that's related to the position. And we're seeing some states who have banned those altogether. So even at the federal level, I think they've talked about banning it, but I don't think that's happened. So we get into non-solicitation and confidentiality agreements. And I'm going to go back to non-compete. I know of a bank, not locally, it's not in Springfield area. They were requiring all their tellers to sign non-competes. So they literally couldn't leave their current bank and go to another bank and be a teller there. Doesn't make any sense. Those aren't going to be enforceable. So make sure you've got business reasons for doing that and they're justified. Non-solicitation and confidentiality agreements, those are actually not a bad thing. So if you're trying to protect proprietary information, you don't want them to leave and take all your employees with you, take your customers with you. And, you know, those might be something that you consider having all new employees fill out. And then interviews, you know, train your managers on conducting interviews. So I don't know if you're all like this. Everybody's struggling right now to get employees, and it's just so hard to find qualified candidates, and they're just not in front of us anymore. I remember back in the late 80s and 90s when I started in HR, it was kind of like, well, if you don't like it, leave, because there's 12 more people lined up to take your job, and we don't have that anymore. So it's I know, a challenge for everyone. So when we do get somebody apply, what do? We're getting ghosted, right? So hello from the other side. I must have called 1,000 times. They're not responding to us. It's a really frustrating process for recruiters. And then guess what? We're so excited when they actually show up because we're seeing employees who are accepting the offer and then they just don't show up on their first day. So I get it. It's very challenging. So just make sure that, in your recruiting process that you make sure that's quick, fast, so you don't lose those applicants that are coming to you. You got to move through this process so that if you wait 2 weeks, 3 weeks to contact them, they're probably already employed elsewhere. So, all right. Review your employment application, your screening and testing processes, and your recruiting documents and checklists. All right, so let's talk about interviewing do's and don'ts. So make sure that, if we're talking about age, you don't ask them when they plan to retire, when they graduated. You can say things like, where do you see yourself in 5 years? Or this bartender position requires that you be at least 21 years of age. It's a job requirement, right? Are you legally old enough to work in this position? If it's a specific job requirement like that, you can ask it, but don't ask them their age. Just say, can you meet the requirements of this position? We get into sex and gender. What gender do you identify as? Do you have a partner? None of those questions are acceptable. We just need to know if somebody can perform the job duties. Marital status, not good to ask specific questions about that. Now, you can't ask if you ever worked or earned a degree under another name, because we might need to do a background check that might need that information to do that background check. Family status, again, don't ask these questions, but you can say, do you have any outside commitments that could prevent you from working the necessary shifts? It could be anything. It doesn't have to do anything with children or anything like that. So be careful of the questions. Make sure they're job related and they're not discriminatory. Same thing with disability. We can't ask, I noticed you were limping when you came in. Is that a permanent thing? Do you have back problems? Again, you can ask, after seeing the job description, are you able to perform the essential functions of this job? That's what we need to know. That's all we need to know. Can they lift and carry at least 75 pounds regularly? Because that's what the job requires. So no health or genetic information. Make sure you don't ask religious questions. You can ask about if they can work the scheduled shift. I know some employers were asking, can you work on Sunday mornings? Do you have to go to church on Sunday mornings? Or do you go to church on Wednesday nights? What religion are you? All of those things. We just need to know if they can work the shift and do the job, the required hours. We get into race, color, national origin, and ancestry. You can ask their current address. Or again, a job requirement. Can they speak Spanish if that's a requirement of the job? Be careful of citizenship. We don't want to ask if they are a citizen. I know for the I-9 process, people feel like, well, I need to know that, right? Well, you don't. You need to know if they're legally eligible to work in the United States is what we need to know. Arrest records. Again, they're not convicted. Right? We don't need to know about their arrest records. They could be wrongly arrested, right? So be careful of those questions. But you can say this job requires handling large amounts of money. Have you ever been convicted of theft? That's very specific to that job. Personal finances, height and weight, military service. I won't go into all of these. They're in the PowerPoint, but just wanted to make sure that that you train your managers on anybody involved in that hiring process, that you're careful there. All right, get into onboarding. Again, make sure you've got a consistent process for that. You're checking things, new hire documents. Make sure you get your I-9 form on that first day. Get your federal and state W-4s, direct deposit. One question I get a lot is, can I force them to do a direct deposit? You can encourage them to, but if they're working for you and they've been reported to check systems through their bank and they can't get a checking account, you still got to pay them somehow. So now that could be a payroll card. You can't require that they go get a payroll card because that's not going to require going through check systems. But again, that's something that you want to walk through and work through. And you might have to write a check if everything else fails there. Make sure you're getting your handbook acknowledgement signed on or before their first day of employment. I can't tell you how many employers I've worked with, and it's 2 weeks later and they're like, oh yeah, we didn't get them to sign that. But or we've got into a disciplinary action situation with an employee who's been there 1 week or 2 weeks, and we're like, okay, let's see the signed handbook acknowledgement that they acknowledged they knew that this was a policy and that they agreed to abide by that, and then we have no signed document. So it puts you in a more difficult situation to enforce that policy. All right, healthcare exchange notice, we're telling employees, hey, did you know that number one, we do or don't provide a plan, and number two, that there is an exchange out there where you can get health insurance. You know, if it's not offered here or you're not eligible for it, you know, all of those things. You don't need to do self-identification forms as part of onboarding unless you're an 100 or more employees and you're required to do EEO-1 or your affirmative action. One thing that I see employers not taking advantage of is the work opportunity tax credit. So this is just free money. And basically, if you Google WOTC, it's going to tell you all of those groups of individuals that may qualify for you to get that tax credit. So if you hire somebody who's in this particular group, maybe it's youth, maybe it's disabled employees. There's a whole list of them that you'll just need to look up. So it's, I'm sorry. Veterans, exactly, thank you. So I can't think of them all at the top of my head, but there's several. I mean, I think there's like 10, 15 groups. So you want to look this up. Take advantage of this tax credit. It was set to expire, and then they have renewed that until 2025, the end of 2025. So we've got several more years here that employers could be eligible for that free money if they have somebody who qualifies under this. It is a process. There's a form they have to fill out upon starting with the employer. And so you need to get that process set up, registered to be able to get those tax credits. Offboarding, make sure you get, again, a consistent process to offboard an employee. Final paycheck and voluntary termination. So in the state of Missouri, you do have to provide an employee's final paycheck to them on their last day of employment if they've been involuntarily terminated. So if I resign, next payroll, right, as normal. But if I walk up to an employee and I have to fire them, I am supposed to have a check ready for them. So a lot of employers, you know, they've got payroll companies. It's literally impossible for them to have a check ready on that last day, or it was an impromptu firing. And so just make sure you're getting that to them within 7 days. They do have the right to request that check. And if you don't provide it to them within 7 days, then you could be fined for doing that. So most employers, I think the fine's like $50. So most employers like, yeah, we'll take the chance, but I'm not recommending that. I'm just telling you what the law is. So.
Payroll companies, are they able to produce that check or cash them out early?
Gosh, it just depends. You have to get with your, so there's lots of different ways you can get that set up. That you may have checks on that payroll account that you could just fill out, you know, have your payroll company tell you what the amount should be. They can run it through their system. And then you just basically are pushing history and you write that check. Most employers don't even have physical checks on that account anymore. So they're really relying on that payroll company to help them get that check produced. So. All right, we get into severance agreements. If you're going to severance an employee, be careful of the laws there, because if you're severancing a group of employees who are age 40 or older, and I'm not talking about one employee who's over 40, there's not an obligation there. But if you're severancing a group of employees who are over 40 due to like a layoff, downsizing, anything like that, there's a whole different severance process you need to go through in order to, and a different severance agreement that you need to go through for those individuals that you're severancing. All right, want to make sure we do all of those. We get into FMLA again. I'm not going to go into a lot of detail here. We're getting close to running out of time, but employers who have 50 or more employees within a 75-mile radius do need to comply with FMLA. I do look at several handbooks that for employers who have like 10 employees, and I'll see an FMLA policy in there because they pulled some handbook off the internet. Don't put that in your handbook if you don't have to follow that law, because now you've created a policy where now you got to follow FMLA laws. And so just be very careful of that. And be careful if you're an integrated employer, a joint employer, a successor employer. It's possible through common management, all of those things, that even though your Fed ID doesn't have 50 employees, if you're under an umbrella where there's common ownership, things like that, and you have to go through that information, you could then be obligated as a group. Again, I can't speak to that. You need to see what your, the way you're set up as a company. There are forms, checklists. If you do have to comply, make sure that you're doing things timely, because you do only have 5 days after an employee lets you know they need that leave of absence to get that rights and responsibilities notice out to them. And then they have 15 days to get that back to you. And if they don't, you're going to have to extend that a few times for them to work with them on it. Sometimes the doctors just don't get it done timely. And then after you get that back, you only have 5 days to send that designation notice out. So very important to make sure those things are happening timely. And let's do those. All right, ADA. Again, most employers are going to have to can take this into consideration. If an employee comes to you and needs an accommodation for a disability, you're going to want to go through what we call an interactive process with them. And that's really just examining what job do they do, what limitations do they have as a result of that disability? Do we need to get medical certification from the doctor so we better understand what their limitations are? Is this the only thing they do and they're limited from doing that? I don't think we can continue to I don't think we can provide that accommodation. Maybe we move them, you know, again, you have to get creative at that point, and start working with them to determine, can we accommodate this? If not, you know, that could mean you move them to a different position, create a new one. It really varies based on all of the individual situation. So these are some things that you want to take into consideration. And then some things that you may consider if you're working with an employee to try to provide that accommodation is, do we need to make existing facilities readily accessible? Do we need to do job restructuring, modify their work schedule, offer telecommuting? So employers used to say, nope, this position can't be done from home. Well, COVID proved that, you know, maybe they can be done from home. So employers are having to reconsider that when they're going through this process. Again, more breaks, all of those things. All right. So again, you know, talking about telecommuting, if you have a policy, make sure it states that it's not a universal employee benefit and not all positions are suitable for telecommuting, because you're not going to let everybody do that. Manufacturing, nobody on an assembly line can work from home, right? So we want to make sure we've got these things in here because it just doesn't make sense. But based on performance, so if they're not performing well at home, you may require them to come back to the office. It's not a guaranteed work arrangement. Things to consider when you're thinking about letting somebody telecommute, is this temporary versus ongoing? And the reason I ask that is because if it's a permanent telecommuting arrangement and they're living in a different state than your work facility, you may now have to file for unemployment, register with the unemployment office, because now they reside in that state and those unemployment benefits will need to be paid to that state. So we got to look at that arrangement.
Can you limit somebody's, if they're working from home, can you geographically restrict them to just one state for insurance purposes?
Your telecommuting arrangement is between you and that employee. Is that what you're asking?
Yep.
Yep. You're not required to do that unless it's a reasonable accommodation for somebody and the courts say, yeah, this is reasonable, you should be able to do this. You know, again, I don't know what that would look like. It's just a process you'd have to go through. But one thing that I do also recommend in those telecommuting agreements, if that's the case, they're working in the state, you've registered for unemployment, the last thing you want them doing is moving every 6 months to a different state. So now you're registering in every state. So your telecommunicating agreement may say something to the effect that this agreement may not, we may rescind this agreement if, you know, that those arrangements change, you know, or they have to notify you if they're going to change to reevaluate whether this is possible. So, which might be hard, right? Because it's just getting difficult. And you can justify that by saying, well, they live too far away. They're not able to come into meetings, and we're not going to pay for their travel. And, you know, those types of things you just have to get into.
Well, I was thinking not only you have unemployment insurance, but you'd have health insurance that would change.
It becomes so much more challenging. Right. You're absolutely right. Absolutely. Absolutely. FMLA, that's another thing to take into consideration if you're over 50 employees. It has to do with their reporting location. So if they're working in Utah and they're reporting to a manager in Missouri, they're the only employee who doesn't work in at the work site, and you have more than 50, it's not about, they're not going to be denied FMLA rights because they're reporting to somebody who is at the work facility where there are 50 or more. So those things come into play too. Not that you'd want to deny them that, but it's just part of it. All right, we get into other types of work arrangements. Those are just, again, things you'll have to work through, consider looking at, oh, I'm sorry, it has to do with their agreement. So if you have a telecommuting agreement, you might want to consider adding information about these different things here. Taxability of the space, dependent care. They can't maybe watch their child the whole time that they're working, you know, all of those things. All right, we get into notices and disclosures. So if you do offer a insurance plan, the healthcare exchange notice is something that has to be provided within 14 days of hire, and that is for all employees. And so we'll get into, there's not actually a penalty for not doing that, so I don't see a lot of employers do that, but just something to consider. And then we've got some other disclosures that are required as part of your insurance plan. These are not necessarily, all these things are not necessarily provided by your carrier or your broker. So the employer does have some obligations in providing these notices to their employees. And as you can see over here, we've got some pretty hefty fines. That's, you know, $127 per day per employee. So these are important things to get out. Benefits, some things to think about. I have a lot of employers who, you know, they'll sign up for a health insurance plan, but they won't get a premium only plan attached to it. And that's your ability to pre-tax those premiums as they're coming out of payroll. And so if you have an FSA, a flexible spending account, you're automatically probably covered because that's a requirement of having that plan anyway. And they usually include all the other plans that are qualified for that. But if you're not offering that type of thing, then you might want to just make sure with your broker that you've got a premium only plan in place. And then we get into kind of our ERISA obligations. You might talk to your broker, do we need a wrap document, depending on how, you know, what types of plans we have. And then your 5500s, again, that's only for benefit plans that have 100 or more participants. Just recently, as part of, kind of started with the CARES Act with COVID stuff and then moved into, I couldn't blank on the act, that was passed in the end of 2020. I'm sorry, you know what it is.
American Recovery.
Thank you, American Recovery Act. So through that, the No Surprises Act came about, and that's basically saying for certain types of services, you cannot be balance billed for that. So emergency. So basically what that means is if you go in for emergency care and you have a surgery, the hospital's in network, your doctor's in network, but the anesthesiologist may not be. And then all of a sudden you get this surprise hefty bill for the anesthesiologist and you didn't even know you were going to have to pay that. So there's some disclosure requirements. I'm sorry, went past that. ACA is really only for employers who have 50 plus with regard to affordability testing, establishing measurement periods, and then whether you have to do forms reporting. And then we get into payroll and timekeeping. There's federal and state reporting requirements. Again, your payroll company is probably doing all of this for you. In Missouri, you do have to pay your employees at least semi-monthly, and your exempt employees, you have to pay at least monthly. Pay statements from in Missouri are required at least once per month. And then there are no federal or state laws in Missouri that says that you have to pay vacation, sick, PTO, anything like that. It really comes down to your policy. Same way with meal periods and rest breaks. There are no laws in Missouri for that, except when we get into child labor laws, there are. And then if your employees take a break of 20 minutes or fewer, then you do have to pay them for that time, no matter what. So be careful there, unless they were to leave the premises, but we'd have to discuss that to see if that's even possible. We get into payroll deductions. Certain deductions cannot take employee wages below minimum wage. So be careful of those laws. You'll want to Google that if you're going to collect money from an employee, like their uniform, for damaged equipment, that when you're deducting that it doesn't take them per hour below that minimum wage. So be careful there. Other things like voluntary deductions, that's okay. It just depends on what it is. Minimum wage in 2020, or right now, is $11.15 per hour in Missouri. Federal is much lower, but in 2023, that's going up to $12. I know that affects some employers. In this market, though, I think we're easily getting up there, so it's not as bad of an issue. Final pay, again, pay on the day of discharge for involuntary terminations. We've talked about all of that. If you have somebody you've issued a paycheck to and they've never cashed it, you can always submit that to the state as unclaimed property. So, and then the WARN Act really only applies to businesses with 100 or more. So the layoffs and things like that, notices, that's not really applicable to small businesses. Promise we're almost done. If you're doing any type of biometrics when it comes to collecting employees' timekeeping information, like putting their fingerprint on a thing, then that information, you may want to consider doing some sort of consent form or agreement because you're collecting that bioidentical information. Be careful of rounding. You cannot round in Missouri or actually federal more than 15 minutes. That's the maximum rounding increment you can do. We get into on-call. Again, just consider what your policy there. If you've got somebody who's waiting to work at home or on call, excuse me, not waiting, but on call, you know, take a look at what are we requiring with regard to how far they can be from work. Can they drink while they're on call? How often do they end up getting called into work and then reporting timeframes? How long do they have to get to the facility if we do call them? So that basically comes down to whether you have to pay them for that on-call time or not. We get into travel time, home to work, generally is not paid, of course. However, and I say that generally, there's are certain situations, and then be careful of crossing regular work hours. So even though an employee, if they work 8 to 5 Monday through Friday, but they travel on a Saturday, sometime between the hours of 8 to 5, you're going to have to pay them for that travel time because it crosses over the regular work hours, even though they weren't necessarily regularly scheduled to work on that day. So if they're a passenger, or excuse me, a driver, you're always going to pay them no matter what. If they're a passenger, you only have to pay them when it crosses their normal work hours, regardless of what day of week it is. So it gets a little crazy at that point. Lectures, meeting, and training. You have to pay an employee for this unless you can meet all 4 of these conditions, that it's outside their regular working hours, it's voluntary, it's not related to a job, and they're not performing any productive work. We get into wage reductions. If you're going to reduce somebody's pay just because, and I'm not talking about changing them from full-time to part-time, that doesn't count. But if you're going to say, you know, I'm going to pay you $12, but we're going to take you down to 11, you need to give them 30 days notice before you do that, according to Missouri law. We've got child labor laws. We get into hazardous work prohibited. That's kind of at the federal and state level for 16 and 17-year-olds. You can't have them working on a scaffolding 100 miles in the air. And then we get into 14 and 15-year-olds. Hazardous work is also prohibited, but then we get into hours restrictions. Is it during the school year? Is it during the summer? What hours they can work, how late they can work, what you have to do with regard to their breaks and their lunches. And then you also may have to get a work permit that maybe their principal signs off on in order for them to work. The child labor laws fines are pretty hefty, so be careful of those. And then we get into overtime, make sure that you're paying at least time and a half. Most companies cannot do comp time. I hear that all the time. Oh, well, you know, they worked 40 hours and then they were going to overtime. So, you know, they did work 43 this week, but we're just going to let them off 3 hours next week. We can't do that. Most organizations cannot do that unless you're having a specific exception. So it has to be within the work week. So if you define your work week as Sunday through Saturday, you have to pay overtime for any hours worked over 40 in that specific time frame. And you also have to include, when you're calculating their overtime rate of pay, if you're paying any of these things, that pay you're providing them for that incentive needs to be included, and then you have to recalculate that rate of pay before you calculate what their overtime rate is going to be. So I see a lot of employers fail to do that. I'm not going to go through this too carefully, but Fair Labor Standards Act does say that you need to classify people as non-exempt or exempt. So if they're non-exempt, they're eligible for overtime pay. Non-exempt, they're not. We're seeing some activity at the federal level on this. And so I think it's going to change. I think they're going to increase that salary threshold, and we're going to see fewer employees qualify for this exemption in the future. All right. Independent contractors, be careful of this. I don't know if you saw the lawsuit with Uber. State of California came in and said, wait, they're free from control. Well, they looked at the ABC test. Are they free from control and direction? Is it outside of your usual course of business? Are they independently established trade, occupation, or business? California said no. That Uber, you provide services, ride services, and these people are doing that. That's your business. You cannot make them independent contractors. And then the problem we have is Department of Labor has their rules, IRS has their rules, and then the states have their rules. The testings all are different, so it just gets a little convoluted. So I do recommend get with an accountant or an attorney when you're trying to determine if somebody's an independent contractor or not. But what happened with Uber was under federal law, they said, oh wait, they can be independent contractors because they have control. They cannot take an order or excuse me, a driving, what do I want to say, a ride. They can refuse to take that one. So they have control. And so they have opportunity for profit and loss. We start getting into, it just gets convoluted at that point. But so be careful on those. Unpaid interns, paid interns, be careful if it's unpaid that is truly related to an educational institution program in order for you not to pay them. And that's kind of the 20-point test under independent contractors. I'm at the end here, so I just wanted to mention these are some of the top things that employees said that employers are not doing well right now. And so, you know, make sure that if you've got employees that you're taking all of these things into consideration, look at your processes, make sure you enhance those and make them a good process for your organization. Make sure you've got job descriptions on all your positions. They do interact with your performance management program, your work comp, your FMLA, your ADA, your substance abuse policies. You're going to refer back to these job descriptions when you're working through those things. And then other considerations, training and wellness. Make sure that, number one, you're educating employees and managers on discrimination and harassment, unconscious bias, inclusion. Develop them, cross-train them, make them feel like they have opportunities within the organization for development. They came out with the 988 suicide line. And that's something that I think it's important to communicate to your employees if they are having those feelings, suicide ideology, anything like that, where they need to talk to somebody about what they're feeling. They can call the national hotline at 988 and they can speak to somebody about that. So I think that's an important thing to share. Compensation, again, keep sure that you're providing equal pay for men and women based on their job. And then look at there's been a lot of market changes, of course, so we need to make sure that we get our compensation program in check. And again, performance. So years ago, we used to say, oh, everybody does annual reviews, right? So, but that's when people had their employees for 10 years and 15 years. That made sense. Most employees don't even make it to their first year of anniversary. So why are we still doing annual reviews? We need to be doing faster, more frequent feedback to them. That might even be monthly, quarterly. Just make sure that you're considering that in your employee base when you are looking at those programs. All right, I'm so sorry. I know we went over just a little bit. I apologize. Any questions, anything that came up?
So for our virtual audience, if you'd like to type your questions in the chat or in the Q&A, Stephanie would be happy to answer those.
And I know I went through those slides pretty quickly, so those will be provided. So if you need to refer back to them, you'll have that information.
Wrap up or?
Just a minute, in case typing always takes longer than talking.
We really appreciate you coming out and sharing all of this information. The presentation was very good. It was there's a lot of information in there. A lot to be careful of, but it's a small business employer. A lot to think about.
Absolutely. Absolutely. Yeah, trying to just touch but not go too deep. It's just hard because there's so many things out there employers have to be concerned about and make sure that they're complying with. No matter if they've got 1 employee or 100 employees, it's important for everybody because we all kind of have those obligations. So, anything?
What are the common questions you've got from people calling?
of them are, 'cause sometimes it's conflict resolution, the employees aren't getting along. Sometimes it's, I've got this disciplinary action situation, am I okay to term them? You know, those types of things, they're not performing well. You know, we sometimes get a multitude of issues going at once, and then it gets a little scary to take any type of action. So trying to work through what's the best practice and what's the appropriate action. So, a lot of those.
Do you think that people, you know, we're getting into a generation that grew up with video games, right? Do you think that that's why it's important for us? Do you think that's a contributing factor why it's important to provide consistent feedback? Because, you know, in a video game, you always know the score.
Yeah. I always say to my daughter, it's like immediate gratification, right? I mean, we're into that mode where if it's not happening at that moment, then it's kind of lost on them, you know. So that's why it's important for employers, you know, let's not wait a year to talk to them about their performance. We need to be having that continual feedback and grooming and developing, and that's what they're looking for. So, any questions?
No questions from our virtual audience?
Did you have any questions?
No,
Okay.
thank you very
Oh,
much for
thank you. I
coming.
appreciate it.
Very
Appreciate it.
much
Thank you.
appreciate your information.
Sure.
And, for more presentations like this, please stay tuned and sign up for the library and scores programs.
Okay, thank you, everybody. We'll see you next time.
Great. Thank you.